Well, good morning. My name is Burke Griggs, and I am an associate professor at the Washburn University School of Law. And I apologize for the less than sophisticated visual treatment on some of my PowerPoints, but Michael Whiteman at Cincinnati Law will be helping me. It's my fault, not Michael's. So we learned to say that pretty quickly when we're dealing with the IT staff upon whom we are totally dependent. But can everybody hear me okay? Great. Thank you for responding in the little balloons. And I will do my best here. The PowerPoint's a little clunky because I have one, thanks to the United States, 81 megabyte slide that I had no idea was that massive. But I've got about an hour to talk about water justice in Indian country. This is one of the more important and certainly one of the most fascinating aspects of water law. I teach natural resources law at Washburn, and my specialty is American water law. And I know we have law schools from the East where water law, you probably think of it as too much of a good thing with humidity and flooding, say on the Ohio and Cincinnati or in the Delaware River Basin in New York and Pennsylvania. But we also have Western schools on this call, Kansas, UC Irvine, and others. So some of this may be more familiar to you than others. But what I'd like to talk about, and give you your money's worth this morning, is basically a series of things. I'm a recovering historian, so I have to give you some history here, the legal background to the doctrines and the laws of Western water, and how they collide, starting in the middle of the 19th century, with tribal claims, tribal realities, and therefore federal law. And from that point, moving from the original, rather intellectual legal collisions of the 19th century into harder questions of social and political and environmental justice in Indian country. And I'm going to conclude with what I call cynical reasons for hope, more realpolitik reasons for progress in Indian country, and non-cynical reasons. And what I want to express this morning is for you to think about native rights and native claims and native access to water as a fundamental civil rights issue. It has been litigated over my entire life. It is certainly going to be litigated for many of you law students out there for most of your careers. My own background in water stems from practice in the private sector, but also representing the state of Kansas in interstate litigation regarding Colorado and Nebraska. But something that I'm most proud of is working with the Kickapoo tribe of Kansas to establish their water rights. While I go through this, feel free to interrupt with questions at any time. If you want to flag it in your balloon, I will try and catch it. If not, then we can have time after my presentation. I'm going to try and get through this in 40 or 45 minutes. But as Dean Pratt, our wonderful Dean at Washburn, knows, once I get started talking about water, it can be hard to stop. So I'll just apologize in the beginning. Let's move on to the large historical picture. Western water law, and by the West, I mean pretty much everywhere west of about the 96th or 97th meridian. That's pretty much the Kansas-Missouri line. Think of it as the Missouri River Basin. That's how I think of the West, and most water people do, because west of a certain point, you need water to irrigate crops. You cannot rely on rain itself. But the original European law of the Western North American continent was a combination of Roman law and Moorish Islamic law. And this came from the Roman and later Moorish occupation of Spain. And when the houses of Castile and Aragon were united in the late 15th century with Ferdinand and Isabel. They commissioned Christopher Columbus, obviously, but part of the Spanish exploration of the American Southwest meant bringing their own approach to legal issues with water. And so even today, where you have small ditches and irrigation systems in northern New Mexico and southern Colorado, many of these systems follow this medieval water system. And it's based on sharing water shortages. It's a very effective approach to water law. And the Mormons, who were not an ethnic minority, certainly a religious minority, followed these Spanish precedents. And here's a picture of a ditch in southern Colorado. This is near the town of San Luis, Colorado. And this is connected to the oldest right in the state. And it's part of an acequia. An acequia is a ditch association. And it comes from the Yemeni and the Arabic, that which bears water. So this legal structure for allocating water rights exists even before we have Western territories, such as the Colorado Territory or the Utah Territory or the New Mexico Territory. But starting in the 19th century, English and the Anglo-American common law system begins to impose itself upon this pre-existing Hispanic system. And in a series of cases, I flagged two of the standard, cases, one from California, the other from Colorado, that reject these Hispanic and English precedents. Again, England is no place to look for the law if you're dealing with water scarcity, right? I mean, the English problem with water is getting rid of it, not finding it and sharing it in times of shortage. So the basic water law of the Western states is prior appropriation, and that has several important characteristics. First of all, it's first in time, first in right. That's a mining law principle. It's applied to water. Secondly, the water rights are severable from the land. What that means is water can be diverted from higher upstream in the mountains and sent through rivers and canals to farmland lower down. The third characteristic is if you don't use these rights, you lose them. They are subject to abandonment. And there are sound reasons for this doctrine. In much of the West, the primary water supplies are distant from good farmland, and there's the need for irrigation. So between the California gold rush of 1848-49 and the 1920s, every Western state adopts prior appropriation. So this is state law, right? Water rights are property rights, so it exists under state law. Now, this all looks great in practice. The problem is irrigation's really expensive. And so many private irrigation projects and companies go bankrupt, and the federal government eventually recognizes that its previous efforts to develop private irrigation, to promote private irrigation, are not going to be successful. And I want to flag a couple acts here just to point out the extent of the failure. The Desert Land Act of 1877 was basically the Homestead Act applied to desert lands. And under the Desert Land Act, if you could show to a representative of the Federal Land Office that you had irrigated land, then you could obtain a patented claim to 640 acres of land. And the historian Richard White has estimated that over 90% of the claims under the Desert Land Act were fraudulent. It's very easy. All you have to just show, and there are stories of this, people taking a pitcher of water, throwing it on the ground, showing it to a witness, hey, I've just watered the ground, that's irrigation, and that witness signs an affidavit saying we have irrigation, and upon that you get title to the ground. So the Desert Land Act is a caricature of Gilded Age fraud. The Carey Act was an effort to devolve federal land to the states that would build irrigation districts. That was only limited in success. What really changes things is in 1902, the United States Bureau of Reclamation, or its predecessor, comes into existence to develop the Reclamation Act, bringing federal power and federal money and federal expertise to build Western irrigation systems. But generally speaking, just as you have in the South with the Civil Rights Movement, a profound mistrust of the federal government, you have a similar profound mistrust of the federal government in the West. The problem is there's even more, I would argue, dependence upon federal money and federal largesse in the West. And one of my favorite historians, Bernard DeVoto, nailed this approach when he described in one of his books, if you can describe the Western approach to federal land management, it's get out, but first give us more money. So what we're seeing in water rights is this individualistic, state law-based prior appropriation system that almost immediately runs into problems due to the size and the challenges of irrigating the West. So at the same time you've got developments in Western water law and water policy, you have a development of federal Indian policy. And I hope most of you are reasonably familiar with, one of the most shameful aspects of American history, one of the most poignant and hard to face aspects is federal Indian policy. Through what you might call the Jacksonian period, the assumption is that the Indians, because they are racially inferior, will simply die away or they will assimilate. And that there is really no need to worry about these tribes. Tribes are relocated thousands of miles. For example, the Kickapoo tribe in Kansas originates in the Great Lakes area in northeastern Wisconsin. They are pushed into Missouri and then pushed into Kansas. Similar tribal movements all across the country. After the Civil War, though, the tribes are not going away, especially large, highly organized tribes in the West, the Crow, the Comanche, the Apache, the Northern Cheyenne, these really large tribes, many in the Missouri River Basin. And starting in the 1860s and 70s, the United States Army starts forcibly locating these tribes on reservations. What is a reservation? Reservation is not just a tribal homeland. It has an important legal aspect, and that is this. Most of this land is in the public domain. It is owned and controlled by the United States. What the United States does with these large tribes during the Indian War period is they forcibly establish a tribal reservation, and they reserve that land for the tribe after first withdrawing that land from the public domain. So the first efforts in the 1850s, and especially after the Civil War in the 60s and 70s and 80s, is we will put these tribes as a corporate whole on the land and let them fend for themselves. In 1887, however, this policy is totally undercut by the General Allotment Act, which allows individual tribal members to obtain land claims similar to, say, the Homestead Act. They're able to obtain 160 acres of reservation land. This, again, is hugely vulnerable to fraud because many Indians are bribed for their land to be conveyed. The Indians are terribly poor and they need money. So the Federal Allotment Act is built on the same sort of individualism that we see in prior appropriation, but like the Desert Land Act of 1877, it enables fraud. And so by the turn of the 20th century, many of the lands within reservations are owned by non-Indians. So there is a combination, quite a complex one, of land that is owned by the tribe as a corporate whole, land that is owned by Indians as private landowners, and land that is owned by non-Indians as private landowners. And with the passage of the Reclamation Act in 1902, one of the big questions is, will there be a diligent effort to reclaim the deserts on reservation land as well as for non-Indians off of reservation land? As you might expect, there are a lot of platitudes and good intentions, but very little follow-through. Now, my next slide is my 80 megabyte slide. I apologize. It gives you some idea of the tribal holdings across the United States, and I wish I had a little more detail here, but I want to emphasize 4 or 5 regions in particular. One right in the middle, you'll see southeastern Kansas and eastern Oklahoma. That area has been in the news a lot in the last month or so because the Supreme Court had a very important decision in terms of criminal jurisdiction over tribal lands. That case has led many people to suspect, well, how does that affect natural resources on tribal land? And legal scholars and many, many lawyers in Oklahoma and the United States are working through that. I also want to flag the area here in the Four Corners area, Colorado, New Mexico, Arizona, and Utah. This is the Colorado River Basin. Many of our largest reservations in the United States are in this area. You have the Navajo, you have the Southern Ute, you have the Hopi, you have large reservations in Arizona. So there's the Colorado River Basin. You also have large river basins in Wyoming. This is the Wind River Reservation that is at the headwaters of the Wind and the Bighorn Rivers in Wyoming. You have the Crow Reservation in southern Montana. And then you have the Milk River Basin, which we're going to get to in a second. And then in the northwest, we have large reservations in Idaho, the Nez Perce. And then on the border between California and Oregon, we have the Klamath. So I'm going to be talking about some of these as we go forward. So to recap, what we have is a series of conflicts, not just ethnic and racial conflicts between Indians and non-Indians, but we also have a fundamental legal conflict. Western water law is property law. It's state law. And it is state law that largely prevails even under the Reclamation Act, because the Reclamation Act generally defers to state law. Yet, on the other hand, you have tribes on very large reservations that are uphill on waste and desert land. For example, the Navajo and Hopi reservations are some of the driest lands in the United States. But they're under federal control. They hold equitable title to their land. The United States holds legal title in its trust capacity for the tribes. And there are both corporate tribal lands and individual lands, as I mentioned, under the General Allotment Act. And then something very interesting happens in 1907. The first interstate water case between two states is handed down under the Supreme Court's original jurisdiction. And in that case, the court fully recognizes a precedent that it only adopted about 10 years previously, which is that when a state comes into the Supreme Court's original jurisdiction to establish its rights to an interstate river, it represents all of the members of the state under the parens patriae doctrine. So you have all of these things, state law, federal law, all sorts of federalist issues, trustee relationships, and the topic of our conference these next couple of days, ethnic and racial strife and hatred. What could possibly go wrong? Well, this is where the story, in my opinion, gets super interesting. Because what we get are 4 of the most far-reaching and unintentionally progressive decisions in American legal history. I am not going to idealize these decisions or the men who decided them. But these are cases that collectively, and the McCarran Amendment in 1952, collectively produce profoundly important and profoundly disruptive legal rights for Native American tribes. So let's evaluate some of these moving forward. The first one is Winters v. United States. If I were more sophisticated, I would show you a map of the Fort Belknap Reservation. It is on the Milk River, which is a large tributary of the Missouri River in Montana. And like many of these reservations established during the Indian War period, what's the purpose? Well, twofold. We're going to clear the Indians off of land that we want, whether that's in Montana or to the east, the Black Hills, which are being cleared out at this point due to the gold rush in the Black Hills. That's the first purpose, get them off land that the United States wants. And secondly, we're going to civilize these savage tribes. The racial animus against the Indians is profound. It is generational. And what's the best way to civilize an Indian? Obviously, turn them into a farmer, because we all know how civilized farmers are. Okay, I mean, this is something that, if it weren't so sad, could be the potential for dark humor. But you have a conflict between non-Indians using water and Indians. And so look at that date. The date of the reservation is 1888, 1889, where the Gros Ventre and the Assiniboine tribes agree to a fraction of their traditional homeland in exchange for security. That's 1888. But then around 1900, non-Indians begin to build irrigation projects pulling water off the Milk River. And the Indians protest. The citizen irrigators in Montana, keep in mind, Montana was only a state in 1889. Pretty young state, okay? And so the issue before the court in 1908 is you have a reservation, you have that is a federal operation. On the other hand, you have state law water rights that are established under Montana law. Who prevails? And the court finds the Indians. And this is their logic. Their logic is we have a treaty establishing the Fort Belknap Reservation. The Indians did not draft that treaty. We're going to construe that treaty against its drafters, the United States, and there is no way you would convey land or reserve land to the tribe without water rights that are necessary to make that land useful. Because as we know, west of the 97th, 98th meridian, land without water is useless. So what the court does here in 1908 is create an implied federal reserve right. Everything that Western water rights are not, okay? Western water rights are express. They are state. They are subject to abandonment. They are anything but reserved. And so tribes placed on these large reservations now have several really important things. They have an old water right. First in time, first in right. Prior appropriation, look who wins. The 1888 reservation is 12 years older than the non-Indian diversions from the Milk River of 1900. So they're first in time, first in right. Secondly, they're very large. Why? The largest water rights in the United States are for irrigation. It is by far the most dominant use of water in the West. Thirdly, these federal rights are not severable from the land. They cannot be alienated from the reservation. So there is this win on paper. So those of you who study the civil rights movement, this is a theme I'm going to be pushing until you disconnect me against my will. You have early on, just like the Reconstruction Amendment after the Civil War, strong legal rights for non-whites. But it's going to take a long time to affect those into wet water. And a profound tension between state law and federal law. The next case, I'm skipping a little bit, is Arizona v. California. You have two states who've been fighting over the lower Colorado since the 19-teens. Arizona sues in the 1930s, but the court kicks it for lack of jurisdiction. Why? Because the United States is an indispensable party, and since they will not be joined, the case must be dismissed. But in 1954, Arizona refiles this case, and the United States intervenes because by now it has huge holdings in the lower Colorado River Basin, national forests, tribal land, national parks. The Bureau of Land Management has millions of acres in this area. And in 1963, Justice Hugo Black, of all people, finds that tribes are entitled to water under the Colorado River Compact, but more importantly, the tribes' allocations will come from within the state's interstate allocation. So in this case, California is allocated 4.2 million acre feet. Well, tribes within California will obtain their federal reserve rights from that 4.2 million acre feet. And there's a lot of water in the lower Colorado River that is allocated to tribes, roughly about 1 million acre feet. So this gets us back to the parent patriae doctrine I described in 1907 with Kansas v. Colorado. Tribes are a federal community, but they are also state citizens. So their water allocations, even though they fall under federal rights, come out of the state allocation established by this Supreme Court decision. The next situation, the next development, I'll go quickly on this, is how do you get the United States to actually participate in these things? Because the United States absolutely hates being in state court. Any of you who have ever practiced in this area, you know that you will never get a fine lawyer from the Department of Justice or the Solicitor's Office in the Department of Interior to agree to the retained jurisdiction of state or state court or state water rights agencies. So, Senator McCarran of Nevada, after whom the airport in Las Vegas is named, leads a federal statute to waive sovereign immunity in situations where states are allocating water rights between them. So, with that, the Congress passes the McCarran Amendment, which allows the United States to be dragged into state court for water rights adjudication. The final case, before I get to the water justice aspect, is the U.S. v. Adair case. This is a classic situation of Indians accepting far fewer acres than they are entitled to historically. So in 1864, you have a treaty between the Klamath and the United States. But over the next 100 years, much of that acreage is sold away, either by the General Allotment Act or through condemnation. But in 1983, the Ninth Circuit holds that the Klamath's water rights survive, and more importantly, when the Klamath negotiated their treaty in 1864, they retained the right to fish and hunt on the Klamath River. And the Ninth Circuit finds that these customary fishing and hunting rights date from time immemorial. So if you want to deal with first in time, first in right, this is an amazing holding showing that, you know, ever since the Aboriginal settlement of the Pacific Northwest, in a situation like the Klamath Treaty, you have rights that predate the European encounter with the United States. Carla, did you have a question?
Yes, so I was wondering if there's a water dispute between a tribe and a state or two tribes, does that move it to being a federal question and move it to federal court?
That's a great question. That is generally litigated in federal court, yes. The only time that we would litigate cases under the McCarran Amendment, putting it in state court, is if it's a water rights adjudication, which is a fancy term for a quiet title action for water rights. So there are a lot of cases out there that originated in federal court, such as U.S. v. Adair, that speaks to this. You also have cases under the Clean Water Act. Tribes can establish their own water quality standards and have had to litigate those. The Clean Water Act allows tribes to behave essentially as states. So, with this background, we have a very complicated legal framework. We have the assumption that water rights are state law water rights, and they are, most of them are, but tribal water rights are this large exception. There's strong legal rights. The problem is by 1950, we have a condition known as over-appropriation. There are more water rights than there is water. And this begins to worry holders of state law water rights. And you build this with the state's dislike of tribes, federal neglect of the tribes. You don't have much movement from strong legal water rights to actual effective water supply. So how do you get from what we call paper water, you have a legal right to water, into what we call wet water, actual water in the stream, water in a reservoir, water at the tap? The basic argument goes like this. Tribes generally negotiate with the United States and the states to integrate their federal winters rights within an overall adjudicated system that includes the state's water rights. So in exchange for less than their legal rights, because they are water rights rich and cash poor, they get state recognition of that tribal water right, and most importantly, the United States usually eases the friction between the tribes and the states by investing in reservoirs, pipelines, water treatment facilities, and others to build storage and to build infrastructure. Since the 1980s, this has been the most important way in which tribes have reached some level of water justice across the West. The players are the people I've already described: tribes, the state water courts, the state court system, state water rights owners, but also multiple aspects of federal power. Not only the United States as trustee, but as the United States as an owner of land. The National Forest, the Bureau of Land Management, military bases, national parks, wildlife refuges, and so forth. Ultimately, however, Congress needs to approve these settlements because under its spending power, it appropriates money to build out water infrastructure. This is where things can get quite messy. And my next slide is way too busy. I'll just let you scan it. These are all the things that can go wrong. And if I had more time, I would detain you on that. But in my involvement with water rights settlements in Kansas, the hardest ones have been racism and federalism, especially conflicts between white landowners and water right holders and tribes who are seeking to obtain land to build reservoirs. We have federal distrust and federal condescension to state entities. I represented the state of Kansas and had to deal with a fair amount of federal know-it-alls. Ultimately, let's say you do have a settlement. Then you have to get it to Congress to be approved. And this is where you can see state-level water injustice and state-level water racism become a cleaner, more sanitized, abstract level of, oh, we don't want to fund this because that's a pork project for Senator Smith's jurisdiction, using, economic or fiscal reasons to continue a structural injustice about water. So just because you have a deal with the tribe, and maybe the state and the tribe have a deal, and the state and the tribe and the Department of Justice have a deal, does not necessarily mean that the settlement goes through. Many settlements have tripped on the steps of the United States Congress. So wrapping up here before I take questions, there are reasons for hope in Indian country, and I've divided these into what I call cynical and non-cynical reasons. First, let's just start with what I usually depend on more in natural resources law: cynicism and self-interest. A well-designed water rights settlement does not isolate the tribes. Okay? So what you need is you need to develop shared interests. And two of the largest take place in New Mexico and Arizona, and this is where the federal money has gone to supply tribes, the Navajo, Hopi in New Mexico, or the tribes in the Gila River Basin of Arizona. Those projects support tribal water rights, but they also allow marketing of tribal water rights to cities such as Phoenix or Gallup, New Mexico, building pipelines from large reservoirs such as the Navajo Dam in New Mexico to reservations and cities. The final one here on cynical reasons is something that's a really fascinating area of the law, and I would recommend the work of Reed Benson from the University of New Mexico, Adele Amos, she is at the University of Oregon, and other legal scholars who have pointed out that environmental interests, which want water in the river, commercial fisheries downstream, say on the Klamath, they have a shared hydrological interest. They want water in the river. They do not want water pulled out of the river for irrigation. Well, so does the Klamath tribe for its customary hunting and fishing rights. So there is another way you can build shared interests from a disparate, set of communities. And one of the more interesting aspects right now is the decline in hydropower relative to solar and wind in the western United States, which is beginning to provide economic reasons for taking dams down. And as dams come down, the salmon returns. And generally speaking, salmon is a far more economically valuable resource than irrigating alfalfa to feed the cattle. The other reasons for hope have to do with a real genuine recognition of tribal identity and tribal customary rights to water. And we see encouraging signs among the 29 recognized tribes in the lower Colorado River Basin. We see tribes developing their own water codes as they have the full right to. They do not have to defer to state law and how they manage those. And also, in many cases, non-Indians are catching up with the tribes in terms of long-term water management, understanding that ways in which both Hispanic communities and Indian communities thought long-term about water supply and not short-term. I'm running out of time. I want to leave some time for questions, but I just have a couple more slides. This is something I mentioned. perhaps you could improve the conversation once I'm finished, to think about this very compelling analogy between the Civil War's Reconstruction Amendment, by which Black Americans gained very strong rights on paper, but with the end of Reconstruction, just 12, 13, 14 years later, entered the period of Jim Crow that did not see a reversal until the Civil Rights Movement. You see this in Indian country. We have that decision in 1908, Winters, and subsequent case law that provides tribes with strong legal rights, but not a real effectuation of those rights into water really until the 1980s and the 1990s. And the reason I've mentioned so much about history is this is not just because I want to indulge in the saddest, one of the saddest, easily, aspects of American history. It's also about property. What tribes have been able to do through the adjudication process is establish a record of water use, proving up their claims that both state and federal courts have recognized. And it's a place where property lawyers and environmental lawyers together have been able to establish strong and effective legal claims for the tribes, actual wet water for the tribes, within the systems of American law. And with that, I'd like to end on a semi-personal anecdote with a photograph I've taken. This is from a book that I've produced, co-authored with my friend Rex Buchanan. This is a cave, Pawnee Cave in Ellsworth County in central Kansas. And many of these caves are near water. This is near Mulberry Creek in central Kansas. It was a gathering place for the Pawnee tribe for hundreds of years. Shortly after the Civil War, a group of Pawnee scouts that the Union had depended upon in the Western theater of the Civil War, the Pawnee scouts they had some encounters with white landowners in this area, and the local army base, Fort Harker, which is near what's now Canopolis Reservoir, sent cavalry, believe it or not, Buffalo soldiers, to round up these Pawnee scouts. They ambushed them, drove them into this cave. We're almost certain it was this cave, killed them all, and severed their heads, and sent those heads to the Smithsonian Institute for further study. And this was in 1869, 4 years after the Civil War. About 100 years later, the heads were returned to the Pawnee tribe. I'm telling you this story not because I was there, it was 1869, but no one who goes through the Kansas public schools knows about this story. It involves Native Americans, it involves African Americans, it involves white settlers, the United States Army, the Smithsonian Institute. Native American water rights are trapped up in all of these complications of American history. And I think the strongest way we can move forward in Native American property rights is through a deeper awareness of that history. So with that, I'll close with a working bibliography. I would emphasize the second and third titles. The first is just a case book if you want to survey it. The second and third titles are focused on tribal water rights and shameless self-promotion. The last book is the book where that photograph's located. I did the photographs, and all the royalties from the book go to local historical societies and the Native American Rights Fund. So with that, I will stop talking and take any questions or help facilitate a discussion. Thank you very much, and I apologize for the bad video connection, but it's better that you see less of me anyway. So thank you.
Thank you,
So, Professor Griggs, I have a
Thank you.
question.
Sure. Go ahead.
So I have a question, which that's a terrible story about the Buffalo Soldiers and rounding up the scouts in the cave. In terms of activism, human rights activism, what are your suggestions as to the most beneficial forums to take? Land and water rights and human rights have been abridged by the state.
That's a great question. And in my experience, the most effective way, Julianne, is through building alliances among multiple tribes and multiple parties. So the Colorado River Basin of the 1950s and 60s was a balkanized basin among many different tribes and interests. Starting in the 1970s and the 80s, the tribes began to cooperate. It's important not to idealize intertribal relations. Many tribes have centuries of war against each other. And
Yes,
that's not always easy to overcome. But seeing that tribes on their own are quite weak and isolated, tribes together can bring in environmental plaintiffs, can bring in NGOs, can bring in access to money. And it's also, where federalism works pretty well, because there are many Congress men and women and senators who are very sympathetic to tribes, even though they don't live in Indian country. So many of the real champions of these water rights settlements have been from outside of the West. So I think you need to think about building alliances and building consensus across legal and political lines.
Great. Thank you very much.
You're welcome.
Professor Griggs, you have some questions in the chat.
Oh, okay. Could you read them? Because I'm terrified that if I touch my computer, it'll blow up.
All right. There's two in there right now. One says, for law students, who should take a course in water law? And the other one is, do tribal courts ever have jurisdiction over water rights disputes involving tribal interests against private interests? If so, what is the extent of that jurisdiction?
Okay, I'll take the easy one first. Everyone should take water law. It's easily the most fascinating and important aspect of the law. Just ask Dean Pratt. But jokes aside, I would also encourage, if your law school offers federal Indian law, it is one of the most complicated and challenging areas of the law because of these jurisdictional issues. And one of the great legal giants of the 20th century, Felix Cohen, the son of Morris Cohen, the great legal philosopher, he was the first one to write the Treatise of Federal Indian Law, which is still in print and is in its current edition, and is the go-to place for federal Indian law. The second question, I'm going to punt by saying it depends. You will have tribal courts that have jurisdiction over tribal water rights within the reservation. So that could include individual water rights held by a tribal member and water rights held by the tribe as a whole. If you have a situation of a non-Indian owning land on a reservation, that water right, if there is a water right attached to that LOT, that water right will be adjudicated under state law. And generally, under the terms of these water rights settlements, the state water rights agency will defer to the tribal court to adjudicate the dispute. But oftentimes that depends upon the terms of the settlement. When we crafted the Kickapoo settlement in Kansas, the tribe agreed to state court enforcement I'm sorry, to state agency enforcement of the water right, and the state was happy to do that because the tribe's water right dated to 1841, 18 years or 13 years before Kansas was even a territory. But these jurisdictional issues can be quite complicated and quite settlement specific. Most importantly, the Department of Justice is not going to be that comfortable protecting Indian water rights claims in either a tribal court or a state court. They would just as soon come into federal court and enforce the tribal rights there. So there is this friction jurisdictionally between the tribes themselves and the federal trustees for the tribes who prefer a non-tribal forum. Michael, other questions? These are excellent questions.
No other questions in the chat.
Okay. Well, I don't want to get in the way of the next presentation, but if you have any follow-up questions, you can reach me via email. Just pull my email up on the Washburn website, burke.griggs@washburn.edu, and we can go from there. And thank you again for including me in this very important 2-day session. Have a great session, guys.